video, I would like to discuss some challenges involved in the implementation of horizontal and sector-specific data access and data portability regimes. The notion of data portability really is an emerging concept in EU policy and EU law. Portability was introduced as a new right in the General Data Protection Regulation, the GDPR, where individuals now have the opportunity to ask for their personal data to be transferred to another data controller. And here it's important to keep in mind the dual objective of the GDPR. On the one hand, it aims to promote the fundamental right to data protection, but on the other hand, it also stimulates the free flow of personal data in the EU, which is a more internal market-oriented objective. And this mix of objectives, you also see this in the notion of data portability, which has what I would call a hybrid nature. It is about individual empowerment, giving individuals more control over how their personal data is used. But at the same time, it also creates thereby more room for competition and more space for new innovative data-driven services to occur. Apart from the GDPR as a horizontal framework which introduced portability as a tool across any sector in the economy, we have also seen more targeted sector-specific frameworks being implemented in the EU, such as the Payment Services Directive 2 for the banking sector and the Electricity Directive for the energy sector. And what this illustrates is that we currently have a quite fragmented regulatory strategy by which data access and data portability is being pursued. And in this video, I would like to highlight a few aspects that I believe are important to keep in mind, considering this fragmented regulatory strategy to reap as much of the potential as possible from data as an input for competition and innovation in a data-driven economy. And one of these aspects is the issue of what I refer to as overlapping legal entitlements. And by this, I mean the fact that various legal regimes and various legal claims can be present in parallel in one and the same data set. And this can occur between individuals, where one data set may reveal information about more than one person, which also means that if one individual ports her personal data to another data controller, this may also involve the privacy interests of a third party whose data is also included in this data set that will be ported to another controller. Also, tensions may occur between the interests of the individual who makes a portability request and the interests of the data controller, who may want to keep data exclusive when it is protected by an intellectual property right, such as a copyright, a database right, or a form of trade secret protection. And here it is important for legislators and regulators to create proactive guidance on how such trade-offs need to be weighed and how such balancing between different interests have to be applied in practice. Because without such proactive guidance, there is a risk that there is a lot of discretion for market players to decide how these key trade-offs between different public interests will be made in practice, and that we will not see all of the desirable use cases of data portability to occur because of the decisions that are made by market players themselves on how they strike a balance between different privacy interests and strike a balance with their own commercial interests in having their intellectual property rights upheld. Another aspect to keep in mind is what we have referred to as spillovers in a co-author paper. With spillovers, we mean unintended impacts across regimes, where the rules in one regime may also influence the interpretation of other rules in a different regime. And these spillovers may have positive but also negative effects. An example of a positive effect is where a sector-specific regime sets up a certain technical infrastructure that can also be relied on for other use cases that are not yet foreseen in the sector-specific framework, but that can still be created by using a more horizontal policy like the right to data portability of the GDPR. An example of this would be the PSD2, which creates the technical requirements for access to data for two specific types of services, namely payment initiation services and account information services, but where these technical requirements may also be useful for other cases, for other types of services that are not regulated by PSD2, but that can still be facilitated by applying the rights to data portability under the GDPR because of its horizontal nature. So here a spillover may occur from the sector-specific regime that sets up a certain technical infrastructure to the horizontal GDPR right to data portability, which may expand further the use cases where data portability would be mandated in practice. Possible negative effects can also occur. So an example is where the wider impact of a sector-specific policy is not considered upfront, and where this creates certain risks for the overall economy. And here again, we can go back to the PSD2, where concerns were expressed about big techs being able to rely on PSD2 to get even more access to data and to increase their control over the overall economy even more, to the detriment of competition and innovation, while the actual objective of the PSD2 was, of course, to facilitate new forms of financial services and would actually had the objective of making the financial sector more competitive. So to prevent these possible negative impacts, it is important to consider what could be the effects of sector-specific regulation beyond the industry that is involved, to also make sure that there will not be any adverse impact on the overall economy when a too narrow focus is taken. So these spillovers can be positive, which need to be stimulated, but they can also be negative, which need to be kept in mind, and where the negative impacts would need to be reduced as much as possible by trying to upfront consider what could be possible effects beyond the specific sector that is regulated. Then to conclude, I think it's also important to keep in mind that we might also need to go beyond data portability to increase competition and innovation for the purpose of a proper data-driven economy. Because data portability are really requests at the initiative of a user. And these user-initiated requests may not be effective enough to create the level of competition and innovation that we want to see in our data-driven economy. So there may be a need to facilitate data sharing beyond these user-initiated requests, beyond the forms of data portability that we already have, for the purpose of stimulating competition and innovation even further. And we indeed see that there are already some policy initiatives on the table. The proposed Digital Markets Act, for instance, has an obligation for gatekeepers to share access to search data with third-party search engines in order to promote competition in the search engine market. Then there is also the Data Act that the European Commission will be publishing in the coming year, which may create further rights and duties to promote data sharing beyond the forms of data portability that we already have. So for further reading, I refer you to these publications, where some of the insights that I've shared with you in this video are also explained in more detail.